Good evening, house guests. Come on in and have a seat and let's talk about the latest iced tea and the Blake Lively docket. So it is past midnight on the East Coast, and it is the end of the deadline for requests for sealing of exhibits and whatnot. And I believe the motions for summary judgment, both on the Wayfair side and on the Blake Lively side. So I'll just take a quick look at that for all of you people who are still up and with us. But first of all, I do have to take a second just to share a little side note. If anybody is interested in off-market real estate, I do have a property coming up in Pennsylvania. It'll be a cash sale, I believe. And if you're interested, please email that address and I will give you more details. All right. So now that we've got that out of the way, let's talk about the docket. And of course, I was going to talk about Isabella Ferrer today, but I totally forgot about this whole unsealing and, so here we are. I'm just going to add this. Oh, okay. So does everybody remember the whole Isabella Ferrer part of it? I know I just did a video on Isabella Ferrer. We did a live stream and then we did a closed captioned. The closed captioned, I try to put a little bit more information in it. So after all of these lives, I will put everything in a closed caption video with as much detail as I can. The docket is so huge, so if I get things wrong, I apologize and please correct me. But remember when Isabella Ferrer got subpoenaed and she threw that big fit? Where is this article? Is this all a bunch of ads or did I miss it? But remember when she got subpoenaed and then she threw that big old fit? Oh, I have to subscribe. Okay. And called it harassment, even though she was so open to providing Blake Lively with the requests that she wanted. Well, it turns out that Isabella Ferrer didn't get her way and she had to sit for a deposition. And in hindsight, I'm not sure. Maybe she could have fought it. Maybe she couldn't have. If she really wanted to, maybe she had to cooperate. And why I say that, I'm thinking PR and career wise, like maybe she had to sit because her career was further being damaged by not sitting. So she thought that she had to sit for PR reasons only, because it still seems like throughout this whole thing, Isabella Ferrer got the short end of the stick and all. She didn't get a movie. She didn't get a casting by Paul Feig. She got an introduction to Sean Levy, but there's nothing in her IDBM for more feature films. And the longer that this case goes on, the more damaging Isabella Ferrer is going to be in this. And the crazy part is that Blake Lively didn't witness anything direct to her. So it was Isabella Ferrer that said something to Blake and then Blake took it to something. Or did Blake say something to her and then Isabella Ferrer confided in her, similar to what Justin Baldoni did? Remember that text? You're safe here. What if you're safe here was just an open trap? Well, we get it. This is in my opinion, because it feels like everything has been a setup up to this point. But I don't think Blake Lively really counted on Isabella Ferrer to be a bigger was an afterthought. And it was really Colleen Hoover's idea to bring Isabella Ferrer to book Bonanza. And maybe she roomed with Blake and they could save a night. I don't know. Because I still question the sleepover party type of thing. But, anyways, the docket was hopping, and I initially thought it was only going to be one or two filings. I'm not sure why I thought it was going to be so little when there's so much at stake here. And Blake Lively really let every skeleton out of everybody's closet in this lawsuit. She dragged in everybody, even people who you would think would be benign. Bradley Cooper, Gigi Hadid, Taylor Swift. They all got swept into this. Christy Hall, Alex Sachs, Sony. And it almost seems like there's a lot more to the story that has done her best to limit what the public can see, and she continues to do so through this docket. And now everybody is scrambling to and just how everybody scrambled to get their requests in before this deadline. And I use Court Listener. I don't have a lot of money, so I can't use Pacer. But one day that'll change. So this is the most recent filing. It looks like a motion to seal was filed by Melissa Nathan, Wayfair Studios, Brianna Butler Koslos, Blake Lively, Jones Works, Catherine Case, Street Relations, It Ends With Us Movie, Justin Baldoni, Jennifer Abel Agency, Group PR LLC, Jimmy Healy, Steve Sarowitz. And then there's a whole bunch of exhibits. And I guess they're supposed to submit these exhibits that they want either sealed or redacted in some cases. You see this? I have to buy it on Pacer. Oh, well, it's like, looks like there's going to be someone else appearing. That's new. So whoever this is, maybe they just filed late and I didn't see it. This is a letter motion to seal for Maxwell Breed. Does anybody remember who Maxwell Breed is? Maxwell Breed is another content, I guess, producer that Wayfair pretty much did like what I would describe or what my press pack, and they had certain talking points they wanted her to talk marketing or their crisis plan was. And so it was just talking points for Maxwell Breed and questions, and she sent a version of those talking points to where longer version of this video. But you can see some of these attachments here. that she includes communications, I'm guessing, in regards to that. Let's see if we can see it. Yeah, and this is just text messages and their proposed redactions. So that's for Maxwell Breed. And it looks like this is all that she wants redacted. And it looks like this all has to do with Brianna Coslow and is that Katie Case? Next, we have a letter motion for continued sealing for Wayfair Summary Judgment Exhibit 273 and Lively Summary Judgment Exhibit 87, 266, and 267. Document filed by Family Hive LLC. Okay, so this is Family Hive is Blake Lively's company. And I believe Family Hive has to do with her hair care company. And it looks like there's some proposed redactions in the exhibits. I would have to buy this under Pacer. Selected parties letter addressed to Judge Lyman from Kristen Toller. Sealing certain exhibits in connections with motion summary of judgment and spoliation sanctions. Document filed by Melissa Nathan, Wayfair Studios, Blake Lively, Jones Works LLC, Jessica Baldoni, Jennifer Abel, Jamie Heath. So it looks like Jones Works is Jones Works and Blake Lively. It looks like everybody's in agreement to seal these following exhibits. And you can see the attachments here. Exhibit Able, MSJ, Exhibit 7, number 2. And we can look all of these up eventually if you want. Just let me know in the chat, and that'll be like separate videos. Let's see. Letter motion to seal requesting continued sealing of Wayfair Summary Judgment, Exhibit 273, and Lively Summary Judgment Opposition, Exhibits 87, 266, and 267. Document filed by, again, Family Hive. And how much you want to bet that Family Hive, Blake Lively, is not a direct owner of? Does anybody think that? Similar to what Betty B. Holdings is saying in their filing of their letter motion, which we could read in a little bit too. Else filed. Again, Jones Works filed. Whoa. Okay. Kristen Tollers. Kevin Fritz. Spoliation. Jones Works is not moving on the exhibits. The court ordered it to refile publicly with redactions in. Okay, I don't understand why she would say that. Anybody in the chat know why? It's an interesting footnote. The parties additionally agree that personally identifying information, including in the form of phone numbers, well, yeah, that sounds pretty reasonable. So we saw Jones Works, Family Hive. Good standing for the clerk. Oh, okay. He's just saying he's there for a family hive. Okay. Oh, notice of appearance. Um, Select a party's letter addressed to Judge Lyman. Motion to seal certain exhibits. Spoliation responsible document filed by Jennifer Abel, Melissa Nathan, Justin Maldoni, Wayfair, Blake Lively. So they're all agreeing on this, it looks like. This looks like Wallace deposition transcript. What else? Lively spoliation. Looks like street relations, Wallace, street relations. This all looks like street relations. SR is street relations. Let's see what else there is. Whoosh. That's a lot, like we said previously. Letter motion to sealing requesting court to continue sealing certain documents attached to the party's summary judgment papers addressed to Judge Lyman from Rachel Pinsky Fizzle, filed by Betty B. Holdings. Let's read this one because there might have been some interesting tidbits in here. This is Blake Lively's Betty Buzz. We're just checking with the chat. Alrighty. In accordance with parties' agreements so ordered by Your Honor, we write on behalf of non-party Betty B. Holdings, Betty B, to move for a continued sealing of certain documents attached to the party's summary judgment paper, specifically Betty B's second amended and restated limited liability company agreement, the Betty B operating agreement, and Betty B's sensitive competitive business information contained in 2 highly confidential board updates. Okay. And 2 years of K1s. Now, is anybody interested in this? Because I kind of am. I know it's trade secrets, but I'm kind of interested. I wonder if it has to do with Blake Lively's reputation, and that's why they want to keep it confidential. But here are some footy notes here. Betty B is a private holding company for 2 operating entities. Betty Buzz, which sells premium non-alcoholic seltzers, and Betty Booze, which sells premium alcoholic seltzers. Plaintiff Blake Lively and her affiliates own a minority interest in Betty B. So she doesn't own a majority stake. The operating agreement was submitted as Exhibit 276 to the Declaration of Alexander Shapiro in support of the Wayfair Party's motion for summary judgment. Really? Okay. The board update dated October 1, 2024 was submitted as Exhibit 268, and the board update dated May 8, 2025 was submitted as Exhibit 269 to the declaration of Michael J. Gottlieb in opposition to the Wayfair Party's motion for summary judgment. The Gottlieb Declaration. The K1s were submitted as Exhibit 278 and Exhibit 279 to the Shapiro Declaration. Why would she want those sealed? And this is why I think it has to do with her wholesome reputation. It looks like 2 pages of deposition transcript of Betty B's 30B6 witness, and there's another footnote, and certain portions of Miss Lively's expert reports. Why would they want that sealed? Does anybody know? Does that make sense to anybody? We attempted to confer with both parties about our request. Miss Lively does not test our proposed sealing request. We were unable to get a response from wayfarer parties despite multiple attempts to reach them. I wouldn't talk to you either. While we understand the court's position on the presumption of public access, which attaches to judicial documents submitted in support of summary judgment motions, as this court has recently stated, the common law and First Amendment rights of access are not absolute. And then it cites some case law. In particular, countervailing factors can overcome the presumption of access and warrant continued sealing or redaction of documents. Stanford versus case law. District court erred in failing to consider and give appropriate weight to the countervailing factors which supported sealing. I get lost in the legalese, guys. A commonly found countervailing factor is the prospect that public disclosure of confidential business information would subject a party to financial harm. Okay, that's fair. Case law, financial information. So if she owned a minority stake, maybe she just got a percentage of the revenue or the profits as like an agreement to use her likeness, or not her likeness, but her image. Is that why? This court recently granted sealing of confidential business information and the personally identifiable information of third parties and documents submitted in connection with summary judgment motions. Okay. Allowing sealing of specific business information and strategies where disclosure may provide valuable insights into companies' current business practices that a competitor would seek to exploit. Citation internal coercions marks admitted. Further, the privacy interests of innocent third parties should weigh heavily in court's balancing equation, and a vulnerable common law exception to the presumption of access. And then there's case law. I really do think she might get a portion of like sales or something like that. And everything has to do with her wholesome and not filing frivolous things. I don't know. As to the Betty B operating agreement, and it contains information about the identity of the members of Betty B. This court already held that the identity of unrelated non-party clients. The excerpt pages 121 and 147 of the deposition transcript of Betty B's witness, which was submitted as a Shapiro declaration. These excerpts, section and appendix of the expert report of Kenrich submitted as exhibit and pages of the expert result. These are her experts and she wants them sealed? Why? I believe this is the PR accountant, Kenrich. I'm not sure who he is. We'll research him. Okay, maybe sealed, blah, blah, blah. In addition, the agreement explains how Betty B has decided to structure and manage its business, which could provide valuable insights into companies' current business practices that a competitor would seek to exploit. See Louis Vuitton. Moreover, the agreement is cited just once. The Wayfair summary judgment, and solely for the proposition that LOL Hata, Lively's wholly owned entity, is a member of Betty B Holdings LLC. So she's a member of the board. Given the extremely limited relevance, if any, of the operating agreement itself, as opposed to Ms. Lively's ownership, Betty B requests that the agreement remain under seal. I wonder if the agreement has to do with like a percent or what she's getting or an interest in what she's getting. Business relationships interest with privacy interest in non-parties would be detrimental affected by the disclosures. So they're just saying that if it's not sealed, it'll hurt the business further. But I honestly think This is just drawing more attention to them. And this is why I think this is important. This piece right here relies extensively on information from those documents, as well as additional financial analysis and calculations based on B's historical performance and forecasts. I think this all pertains to her marketing, and they don't want to have to explain how she can make sales rise and fall, if that's what it means. I'm not a lawyer, and I could be totally wrong, but um yeah, maybe they might, not like they're going to drop her, but it's not direct. It's not her direct business. It's a distant. I mean, it would be different if she owned it and she received 100% of the profits. You know what I mean? But that was Betty B. They don't want things unsealed. I know that there was Sony. Here we go. Sony. I'll just make this bigger for everybody. For everybody who's awake with me. Thank you for joining. This is Sony's letter, request for sealing. We write on behalf of non-party Sony Pictures Entertainment, and Sony Pictures is actually mentioned quite a few times between both of them. Thanks to Blake Lively and pulling in Angie Giannetti. As you know, Angie Giannetti, the Sony representative who agreed to be on set, was shown that image prior to for it being shown to Blake Lively. And then Blake Lively went and complained about it might being corn. And Angie Giannetti is surprised at Blake Lively's reaction, even though Angie Giannetti is later named in the 17-point agreement for the creative process. But anyways, pursuant to Rule 4B of Attachment A to the court's individual rules to request that the court maintain under seal certain portions of documents filed in support of the Wayfair party's motion for summary judgment, Docket 960, Plaintiff Lively's opposition to the Wayfair party's motion for summary judgment, the Wayfair party's opposition to Plaintiff Lively's motion for spoliation sanctions, and third-party Plaintiff Abel's opposition to third-party defendants Jonesworks LLC motion for spoliation and sanctions, Docket 1009. SPE has carefully evaluated the sealed documents and requests that the court seal a very modest amount of Sony Pictures Entertainment material filed in connection with the aforementioned filings, narrowly tailing portions of deposition testimony, which deposition testimony we see that it was Angie Giannetti that was deposed. We saw that in previous videos. Actually, we saw that in both of the birth scenes. I think one where Blake Lively admits that it's corn, and is Blake Lively honestly silencing Sony. Maybe Sony doesn't want this out either. So it looks like there's something in here that nobody wants it to be out. So I don't know what happened. Maybe it is true. Maybe this all lends to Blake Lively threatening Sony, like there was that rumor on Reddit. Does anybody remember that rumor of Reddit? Maybe this has something to do with it. I don't know. But whatever it is, Blake Lively and Sony don't want it shown. Narrowly tailored portions of deposition testimony, texts, and emails of Sony Pictures employees, highly sensitive terms of a commercial agreement between a Sony Pictures Entertainment affiliate and certain of the waiver parties, and personal phone numbers of Sony Pictures employees. I'm wondering if this has to deal with Todd Black and Angie Giannetti, or at least Todd Black. I am wondering if that has to deal with Todd Black. No presumption of public access attached to the Sony Pictures Entertainment material because none of it is relevant to this court's judicial function in considering the summary judgment and sanction motions with which the material was filed. No presumption of. Okay. Sony Pictures Entertainment requests for sealing should be granted for this reason alone. At most, the Sony Pictures material plays a negligible role in the court's exercise of its judicial function. Any presumption of access that could attach to the material, therefore, is low and easily outweighed by the privacy interests of Sony Pictures employees in the testimony, texts, and emails at issue, and Sony Pictures Entertainment commercial interest in protecting the highly sensitive financial terms of its production, financing, and distribution agreements. I wonder if this has to do with the edits. Given that the, at best, negligible relevance of the Sony Pictures Entertainment material to the filings before the court, any opposition to the sealing request would not appear directed at advancing this case, but rather at harassing or embarrassing non-parties to gratify private spite or promote public scandal. Did they just say that? To gratify private spite. Sony calls Blake out. Sony calls Blake out. Sony supports Wayfair. Does anybody see that? Hi, chat. Hello for everybody who's up late with me or up early. I wanted to jump on after some of the lives and just see how busy the docket was. We are reading Sony's letter. There will be a video, longer version of this in a couple of days. I have to catch up with my Jenna Redfield in reading her whole deleted Substack. I want to get that out. I know that it's on CJ's, but I wanted to get out in video form and just give my perspective because I think there's some things that need to be focused on. But right now, this is Sony's request to seal. They're requesting limited redactions, which I think is fair. But this last part, I just want to highlight. Any presumption of access that could attach to the material, therefore, is low and easily outweighed by the privacy interests of Sony Pictures Entertainment employees in the testimony, texts, and emails at issue. I'm guessing that is Angie Giannetti again, and to Sony Pictures Entertainment commercial interests in protecting highly sensitive financial terms of its production, financing, and distribution agreements. I think that might have something also to do with Blake's subpoena as well. I want to find out if who subpoenaed who. Given the, at best, negligible relevance of the SPE material to the filings before the court, any opposition to the sealing request would not appear directed at advancing this case. So if it if I guess what they're saying, if everything was unsealed, it's not going to help advance Blake Lively's case. But rather at harassing or embarrassing non-parties to gratify private spite or promote public scandal on matters irrelevant to this issue before this court. Nixon versus Warner's communication. So Sony is calling it out to gratify private spite, whoever that refers to. The court should grant Sony Pictures Entertainment sealing request in full. The material and grounds for sealing are summarized in the following table and explained further below. Declaration and exhibits not relevant to the performance of the judicial function and privacy interests of non-party employee. I think that's a deposition or a docket number. It's redacted, of course. Memorandum of Law, docket 90, exhibit 23. They want to redact a dollar figure, which is fair. Not relevant to the performance of the judicial function. This is Shapiro, docket 5472. Not relevant to the performance of the judicial function. Privacy interests of non-party employee. So if you want, we can take a look at each of these exhibits to see what they're pertaining to. Looks like BL text messages and redactions not relevant to the performance of the judicial function. Privacy interests. Wayfair, maybe? Is that WF and Sony? Not relevant. Looks like a Shapiro declaration and Rule 56.1 statement, redacting of a quote. 196, and this looks like it's BL to Sony. And let's read these footnotes here. Hi, chat. Hi. So Sony isn't backing Blake Lively. That's, I think, crucial. Yeah. They called it out, and I hope, who thinks that the media is now going to pick this up now? They have to. Sony calls out Blake Lively. Don't you think that they are? I think that they are. And it's time, because she brought in Sony. She made Sony a witness to her own SH claims. You know what I mean? She I'm going to say ignorantly, because in the context that she did not realize, Blake Lively did not realize that a post-birth family, I'm going to call it a family photo, in the most sensitive time was taken. She thought it was just her. I think that was a consensus with other videos I've seen tonight. They're saying the exact same thing too. Yeah, I hope mainstream media gets a hold of this and runs with it. I also hope that the mainstream media highlights the Jenna Redfield problem and the PR behind it, and how it is so easy for misinformation to go along and I want to know personally who those two journalists were who refused to report on the SH and possibly SA of it all. Because those two journalists did their job in this case, and the New York Times came and just ran with it. So now I really think that the New York Times is going to be sweating too. I'm going to read this. So Sony Pictures Entertainment has proposed targeted redactions for all exhibits that are the subject of the sealing motion, except for Shapiro Declaration Exhibit 23, Docket 96323, for which Sony Pictures Entertainment requests sealing in full. Sealed copies of the exhibits are attached to this motion with the proposed reductions highlighted as reflected in the above table. Portions of the exhibits are issued and quoted in the Wayfair parties and Lively Rule 56 statements, and the two memoranda of law and opposition in Lively's motion for spoilage sanctions. So she drew in Sony for her spoliation sanctions. Sony Pictures has attached excerpts of the foregoing 51 statements and the memorandum of law in opposition to the spoilage sanctions, identifying the specific Sony Pictures material for which redactions are permanently sought. To the extent those excerpts may include redactions, those redactions concern information designed by the parties or non. I'm taking a look at this 56.1. Hang on, guys. I have to. Let's see what they're talking about. I'll share my tab. So as you guys know, this is how I search the docket. I know other people do Control F, which is good too. There's no shame in research. And what? Docket. You know what? We'll do it this way. No, this isn't it. That's Rule 56 statement. Let me see. Which one is it? Such Jennifer Abel. That's Jones Works. For Abel. Let me see. I'm just wondering if it's in here. Try a different way. Bet you if we put SE, actually, what are they talking about? 96323. 963. You can also search by docket number. I guess it didn't work for me, huh? Usually do this on my phone. I'll do 964. See if it did it. 964. It's all 964, and you can see Sony's in there. 963. So we're on 963, right? So now we're looking at the attachment 23. Should match. That's a financing agreement. What else were they talking about with that document? Okay. This is Lively's 51, Rule 51. Rule 51. 51.6. Let me see if I can find it that way. Because it's hundreds of pages. That's why I don't want to click on it. So I don't think it's that. Here it is, filed by Blake Lively, I think. See. Memorandum of law and supporting material. I want to know what they were talking about. Rule 51.6 statement 288, redacting quotes of exhibit 197. Again, it gives this docket. Rule 56 statement. Here it is, counter statement. Okay, so this is finance. It's not relevant. Why would you want to do this? This is our Darvo person. Declaration, exhibit, expert report of Jennifer Freed, redactions of material concerning Sony Pictures Entertainment, not cited in opposition papers at pages 16 through 21. Docket 106. I don't understand why is Sony and the Darvo expert attached to each other? I wonder, why would Blake do that? Why would Blake tie Darvo and Sony together? Target citing, redactions. I can do a deep dive into all of these exhibits and figure out what they're talking about and why they want them to. Might give us a clue. Jones Works. The mere filing of a paper or document with the court is insufficient to render that paper a judicial document subject to the right of public access. And it gives some case law. Instead, the item filed must be relevant to the performance of the judicial function in order for it to be designated a judicial document. A document is relevant to the performance of the judicial function if it would reasonably have the tendency to influence a district court's ruling on a motion or in the exercise of its supervisory powers. Okay. If the document sought to be sealed or not relevant to the performance of the judicial function, no presumption of public access attaches. Okay, fair. If presumption of public access applies, continued sealing of documents is justified when necessary to prevent higher values, provided the sealing order is narrowly tailored to achieve that aim. As this court has recognized, such highly values include protecting significant substantial privacy interests, such as the physical safety of litigants, witnesses, or third parties. They are calling everybody out. Thank you, Blake Lively, for endangering everybody. And when I say everybody, I mean the third parties and the content creators. Because I'm sure they're getting harassed too. Docket 1027 at 3, there was case law as well as protecting confidential commercial information. None of the Sony Pictures material, a narrowly tailored subset of Sony Pictures Entertainment produced information designated AEO under the Protective Order Docket 125 is relevant to the performance. For the reason explained below, the Sony Pictures material should play no role in the court's exercise of its Article 3 duties in resolving the motions for summary judgment and sanctions with which the SBE material was filed. Even if it did, any role would be negligible with a low presumption of access, outweighed by the privacy interests of non-party individuals and employees. Sony Pictures Entertainment commercial interest in the highly sensitive financial terms of its contract with Wayfair that would irreparably harm Sony Pictures Entertainment if disclosed. I wonder what that has to do with. Okay. Sony Pictures Entertainment has judiciously narrowed its sealing request to the greatest extent possible in seeking to protect its private interests and those of its employees. Do you see how it says Wayfair? They include Wayfair in the protecting, and I like that. I mean, that's how I'm interpreting it. Yeah, MSN is unfortunately is in BL and RR's pocket. Shapiro Declaration. This is sensitive deposition testimony of a Sony Pictures employee that is not cited in any party's filings. The testimony SPE seeks to redact on page 26 was included in the Wayfair party's motion of summary judgment only because it exists on the same page as other testimony of the Wayfair party cited in which Sony Pictures Entertainment is not seeking to permanently seal the testimony. Sony Pictures seeks to redact on page 236. Is not cited in the party's motions. The redacted testimony, therefore, cannot possibly have any relevance to the judicial function. Again, here it is. The only on-small basis to unseal such testimony would be to gratify private spite or promote public scandal and private third-party disclosures, further supporting that it should be permanently sealed. Gratify private spite. That's the second time we've seen that in this, right? Widely counter statement. Is this paragraph 16? Just checking, this is paragraph 16. Okay, so this is paragraph 16 in Blake Lively's counter statement to which they are referring to. Although Wayfair and its employees provided some administrative, legal, and operational support to enter this movie on the film that is common in the film industry, and it entered this movie, paid Wayfair blank those services pursuant to the terms of Wayfair's co-financing agreement with Sony Pictures subsidiary Columbia. Okay, I don't know if that's a dollar figure. Yeah, I think so. Exhibit 23 is a co-financing, co-production, and distribution agreement between SP affiliate, Columbia Pictures Industries, Inc. Oh, I didn't even know that. And certain of the Wayfair parties, part of which is quoted in the Wayfair parties memorandum at law, page 47, and Rule 56. So that was paragraph 16. See, I can read that. I just got to find everything else. The exhibit contains extremely sensitive financial and distribution terms. Well, that makes sense. What else? Financing. This is all about financing. Here's Jed Wallace, docket 1027, pertinent sealing this action. Confidential business information of non-parties, Jed Wallace, and street relations. Wait a minute. The agreement terms are confidential commercial information and trade secrets of the type courts in this circuit routinely seen permanently. This is case law. Docket 1027, permanently sealing in this action confidential information of non-parties. So now they're sticking up for Jed Wallace. So now they're like, Blake, you forgot this, so we're just going to advocate for the people that you are picking on. That's how I see it. You guys see that? Just going to check in with the chat. So we saw two of the same, I will say, PR statements, and now we see advocacy for Jed Wallace. The court should seal the agreement in full in addition to specific quotation from the Wayfair memorandum at Rule 56 statements, which are immaterial and irrelevant to the Wayfair summary judgment. Okay. Business information, that's reasonable. Shapiro Declaration, Exhibit 120, Docket 1054, Shapiro Declaration, Exhibit 72, 95472. I wonder what that docket was. Exhibit 120 is a text message thread to which SPE has proposed a targeted redaction over a single text that is not relied upon the Wayfair Party's summary judgment motion. The document is cited in the Wayfair Party's Rule 56.1, paragraph 208, but in support of a proposition unrelated to the specific message, SPE seeks to redact. Exhibit 72 also is a text message thread in which SPE has proposed targeted redactions over text that the Wayfair parties, again, do not rely upon for their motion. The docket is cited in the Wayfair parties Rule 56, paragraph 61, but in support of proposition unrelated to the specific messages, SPE seeks to redact. Exhibit 179 is an email chain. Proposed targeted redactions over specific communications that were not relied upon. Wayfair Party's summary judgment motion. The document is cited in the Rule 56 at 271, but again in support of proposition unrelated to the email chain. So they are just saying that this doesn't have anything to do and cannot have any relevance to the judicial function. Again, they want counter statement 56.1 statement at paragraph 288. Exhibits 196, 197, and 198 are text and email threads cited in paragraph 288 of the parties' Rule 56 statements, dockets 953 and 1074. That paragraph is in turn cited once in the background section of Wayfair's memorandum of law. The information is not material to resolution of the summary judgment motion, reflects private emails from non-party employees who are not even deposed in this case and lack foundation context and are hearsay. So they involve text messages. Okay, from Sony, it looks like. They can't do hearsay. And then we have Garofalo's declaration. And again, sanctions 21 and 32 are the same text thread. One word from one text is quoted in one sentence in the background section of the defendant's response to Lively's motion for spoliation sanctions. Another is in Abel's opposition. And these look like they relate to inflammatory and irrelevant statement from non-party employee who was not deposed in this case. Wow, okay. Unsealing, permitting them to be unsealed, especially where it has no bearing on the court's exercise of judicial function, would improperly antagonize or harass innocent third-party employees with potentially embarrassing conduct. Wow, Blake Lively really just dragged everybody in this. Again, email and personal phone numbers of non-party employees. I wonder if they did that on purpose. Gottlieb, why would they want this sealed? Counter statement 122123. Exhibit 96 is the expert report of Jennifer Freed, retained by Lively to provide testimony about psychology theory. Lively submitted the entire report in opposition to the Wayfair Party's summary judgment, but only specific cites pages 10 and 16 at paragraph 442 of Lively's counter 56 statement. The proposition that paragraph 442 does not relate to SPE. The report nonetheless discusses SPE policy and describes it in detail, purporting conduct of an SP employee taking out of conduct, all of which is completely irrelevant, and underlying motions as demonstrated by the fact that this material is not cited by Lively in her opposition papers. Okay, what is that? It's in her counter statement. Is that what I have pulled up? Paragraph 442. Is it in here? All right, guys, this is the counter statement. This is paragraph 442, which is completely redacted. For context, we'll start with 440. This is in context. Maybe this is in context. On December 23, 2024, redacted. This is a Baldoni 10-7 transcript. This is Lively's declaration, by the way. Lively had concerns about Baldoni's unsolicited disclosure about his, I don't know what this is. But whatever it is, at 442, here's the Freed report at 10 and 16. What did the letter say? Lively's counter rule 56.1 statement, and these are all the paragraphs too, 122, 123, 138, 141, 144, and 572. But I wanted to look at this, at paragraph. The proposition 442 does not relate to SPE. The report nonetheless discusses SPE's policy and describes it in detail purported conduct of an SPE conduct taken out of context. I'm thinking out loud, guys. Sorry. So 442. Because in 443, this is about her loaner agreement. But 440 is talking about December 23, 2024. Above that, prior to Lively stuck with Baldoni's former, and this is a declaration. Lively never asked Baldoni whether he was And that's another thing. This is Lively. This is all about up here. This is all prior. These are all text messages, and here's Giannetti. This is 431, and they don't mention anything about that, I don't think. It's just interesting on how much that they can hide with all these redactions, and you can just go down the wormhole and be like, but apparently this talks about their policy. So that's interesting. Paragraph 121, 123, 138, and 141. Unnecessary criticize the same PE in a manner irrelevant to the motion. So what's 121 then? They're calling her out. Finally. Let's see where Giannetti is in this. See if those numbers correspond with because I want to see the early numbers. Because Angie Giannetti was in her 17-point agreement, and oops, I went too far. And Blake Lively credits her. So Angie Giannetti. It looks like. Aha. So Angie Giannetti knew about this meeting, and okay, I didn't know that. Next, what paragraph is this? 7. 19. 30. Oh, even bill. Okay. And this is from Angie Giannetti. Oh. Angie Giannetti sent Baldoni notes to Lively. Oh my God. Is that what there's? Oh, is paragraph 30 in there? Angie Giannetti is involved in the location. They wanted an R rating, and this is an 86, 84. They're talking about rating. 87. 119. Okay, 119 is the birth video. I'm going to check in with the chat because I've been ignoring you guys. I wonder if Blake's bullying a Sony rep who wouldn't go with her. Sob story through the filings. Well, does anybody remember the Darvo video? And I was like, I wonder if Wayfair is against Blake Lively. And then now it looks like Darvo is being used against Blake Lively by Sony. So if Blake Lively wanted to call Darvo, Sony was like, I got you. By the way, Blake Lively, stop harassing our peoples. Because I can't say that this is Angie Giannetti, but some of the paragraphs are referencing, and I feel bad because I kind of exposed her But I'm just trying to see more context of what they're trying to show. And if I'm totally off base, I am totally off base. So we'll start at 119. And they're worried about paragraphs 122, 123. Unnecessarily criticized as a private person and not party to this. So what is 122 and 123? Here's Janetti at 119. $120, $121. So 121 is whatever, undisputed that the quoted language appears in Gianetti's deposition, but Lively respectfully refers the court to the deposition transcript for its. So this is from Angie Gianetti's deposition. Am I reading the wrong one? Okay, so that was 121. So now we're getting to deposition territory. 122 is also Angie Gianetti. So Angie Gianetti, they are trying to protect 122. Sorry, guys. So now Sony is trying to protect Angie Gianetti that Blake Lively pulled in this Hot Mess Express. Because this now is a Hot Mess Express. Now Sony is saying that Blake Lively, who Blake Lively was like, ooh, totally wrong. But they're calling out Blake Lively. This is my opinion. What does 123 say? Paragraph 123. Well, I don't know. 122, was there relevance of 122? 122, Lively, Gianetti, Baldoni, Robbins. They want this sealed because this guy is probably criticizing this person. What does it say in there? Exhibit 124 is the expert report of Michael Robbins. Miss Lively's expert on harassment, and Exhibit 17 is a transcript of the deposition. SPE seeks to redact narrowly tailored portions of these two exhibits that unnecessarily criticize the same SPE employee. SPE is not a party to this action and was not responsible for the production of the film. SPE employee whom the Freya report, Robbins report, and deposition attack, and whom paragraphs 122, 123, 138, 144, or 144 and 141 and 572 of the counter 56.1 statement unnecessarily criticize a private person. So we saw, and I'm just reading from this, 122, 123. So we saw 123. This is the start of 123. Here's her deposition. Lively's response, undisputed. Lively respectfully refers to the court. Okay, here's a Robbins report that they're talking about. Was it 124 as well? No, 138. $132, 133, COVID, 134, blacked out, 135. Here's an email. BL something. I said 138, right? Giannetti again enters the picture. Sachs, Giannetti, 137. May 28, discuss production with fellow cast member. Undisputed, 138. Wiley did not contact Wayfair's HR department during the production, nor did she file a formal sexual harassment complaint with Sony or Wayfair's HR department at any time. Oops, sorry, guys. I teeter-tottered. And we fell down. So this is what Sony. Wiley did not contact Wayfair HR department during the production, nor did she file a formal sexual harassment complaint with Sony or Wayfair's HR department at any time. This is an email from Symphony Barnes confirming that Lively did not make a complaint to the HR department. Lively does not dispute this. She did not. And she says she did not consult Sony's HR. But then she backs everything out, and this looks like this is in reference, I bet you, again to Robbins criticizing the defendant's reference to a formal sexual harassment complaint is vague, undefined, and appears to be a legal conclusion. The side materials do not support any implication that Lively failed to report her concerns. Ooh, did anybody catch that? Does anybody think that Sony is hoping that we get deep dives into these paragraphs, or does anybody find these paragraphs interesting? I know we kind of went down a wormhole, and I was really here to talk about Isabella Ferrer, and I'm going to talk about Isabella Ferrer hopefully in the morning. But it was just interesting to see what they want hidden. Again, okay, here we talk about Alex Sachs, pants, wardrobe, trailer. Giannetti is in there. 140. What about 141? 141 is completely redacted. I'm not sure what it's from, but the plaintiff's response is undisputed that the quoted language appears in Giannetti's deposition, but Lively respects, so they want that sealed. Even though something, and then Robbins, her expert, is criticizing Sony, is what Sony is saying. What else? 144. Let's take a look. See what it's in reference to. Again, Giannetti is mentioned still throughout this. 143. Now we get to 144. Now we get to her testimony. Her response. She's not disputing it. But then there is this. So this report must be criticizing Angie Giannetti. I mean, I can't tell you for sure because we can't see anything. But it looks like it's Angie Giannetti that they're trying to protect. What does the chat think? What else is there? And there'll be a video version because I know my audio is horrid, and I apologize for that, guys. 572. Let me see if I can jump there. Is there a paragraph 572? Here we go. 572, Michael Robbins. And I don't know why they want to keep this sealed. Why do they want to keep this sealed? Michael Robbins is a blah, 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 blah expert, AWICH. I might as well give the respect to it. An expert on harassment, discrimination, other employment matters, opined that, oh my God, so he's talking about Sony. Did Blake implicate Sony? Blake implicated Sony in her own. So Blake is, in my opinion, Blake is just backstabbing everybody. Not disputing, but rejecting it all. Okay. Yeah. She calls it redacting. All right, guys, that I think I'm gonna call it a night. I have to get up in the morning. We will cover Isabella Ferrer, and what she's got going on. So I'll be there like 6:30ish. I'm gonna get to bed. I'm sorry I'm late. I wanted to give time to the other creators who are masters at this, a chance to talk about it. But this will be a long form video. There will be more. There's going to be a long form on Jenna Redfield. I've already done a long form on Isabella. Go out and check that out. Good night. I love you guys, and I'll see you in about 6 hours. Bye.